Okay, so good morning and welcome to all our viewers this morning. Thank you for joining us. Just to let you know that we will only have one speaker today as Amelia Motsepe has had a family emergency to deal with. So I'll hand over directly to Alice Brown, who's going to give an overview of probono.org's project in respect of HIV and TB.
Good morning, everyone. Thank you for joining us this morning. This is a webinar in a continuing series of webinars that Pro Bono has organized having to do with HIV/AIDS and TB. Probono.org is a partner along with several other civil society organizations here in South Africa that are looking to help improve the legal status of key and vulnerable populations, particularly in the context of HIV/AIDS and TB. This is a program that has been sponsored by AFSA, the AIDS Foundation of South Africa, and that global sponsorship actually comes from the Global Fund. So we are one of a number of recipients of funding to help promote the human rights of key and vulnerable populations in the context of those two pandemics, the HIV/AIDS pandemic and the TB pandemic. This morning, we're going to look particularly at TB. We've already had a number of webinars that have looked at various aspects of the AIDS pandemic and the legal implications for key and vulnerable populations in that context. But this morning, we will particularly look at TB, and that's the background for this webinar. I think I should hand back at this point to Chantel, and she'll probably do an introduction, and then we'll take it from there. But once again, on behalf of probono.org, thank you very much for joining this webinar this morning.
Thanks so much, Alice. So yes, just to give you an overview of the situation of TB in South Africa. South Africa is one of the countries with the highest burden of TB in the world. And it is estimated that out of 500,000 cases of TB, about 66% of people are infected with both HIV and TB. So it becomes a double burden on our health system. So however, despite these high rates, TB is largely neglected in national programs and in research agendas. And that's why it's been so important for probono.org to actually raise awareness about this issue and for lawyers to start talking about it. Because despite the fact that TB, we've known about TB for so many years now. I mean, I remember being at school and getting those pamphlets from Soul City where it spoke about TB and HIV. I mean, that was, 15 years ago. There's still a lot of stigma and discrimination that exists, mainly due to the fact that TB is an airborne and communicable disease. And it's also now largely been neglected due to COVID-19. So even though our constitution doesn't specifically mention TB, there's obviously the equality clause that legal practitioners can rely on. And there has actually been a court case that dealt with a prisoner who was contracted with TB, and that's Lee versus Minister of Correctional Services. And we will be including that case on our website so that you can use it. Emilia Motsepe, who unfortunately couldn't join us today, actually drafted a very useful legal resource on HIV, AIDS, and TB for the website, and you are welcome to use that. So that's just a bit of an overview of the general issues regarding TB. And now I'm going to hand over to Lusanda Rapulu, who is a director and partner at the international law firm Bowmans, and she's the head of employment. And she will be dealing on a very specific issue that we found with TB, and that is in respect of employment. So I'll be handing over now to Lusanda. And just a reminder that if you'd like to ask any questions, you're welcome to do it in the facilities on Zoom. Otherwise, you can do it at the end. Okay, Lusanda, if I can hand over to you.
Thanks, Chantal. Good morning to everyone. I'm just going to start by sharing my screen. Sorry, just give me a minute. Can you just confirm if you can see my presentation, Chantal?
Yes, we can see it.
Okay, great. Thank you. Okay, so as Chantal said, I'm an employment lawyer. So for the purposes of this morning, I will be talking in relation to the impact of TB in the workplace. There are a number of statutes that are relevant for today's discussion, starting with the Constitution. The Constitution of the Republic of South Africa specifically talks about two rights that are relevant for this morning's discussion. The first being the right to fair labor practices that's contained in Section 23 of the Constitution, and the second being the right to privacy that's contained in Section 14 of the Constitution. Other legislation that's relevant and that I'll be going into sequentially as we get to them are the Labor Relations Act, the Basic Conditions of Employment Act, the Employment Equity Act, the Occupational Health and Safety Act, the Compensation for Occupational Injuries and Diseases Act, the Protection of Personal Information Act, the Mine Health and Safety Act, the Occupational Diseases in Mines and Works Act, and the Healthcare Workers National Health Act. For purposes of today and looking at the employment relationship, I thought it would be useful if I looked at the employment relationship through the life cycle of the employment relationship and how it is that a person having TB may be impacted throughout the life cycle of the employment relationship itself. The first stage that would be relevant would be the recruitment stage. So at this stage, the person is not yet an employee. They're still an applicant for employment, and therefore they don't have the protections of employment law that apply in relation to people who are already employees. But despite that, they still have some protections. The first would be the right to privacy as contained in the Constitution, and that right to privacy applies to all persons. Now, in relation to a person who has TB and in relation to their TB status, they would be protected by the right to privacy if they disclose the fact that they had TB. Now, like all the rights contained in the Constitution, the right to privacy has limitations. So, for example, if you disclosed in the workplace as an applicant that in fact you do have TB, it may be that it is shared, for example, amongst the panel that's interviewing you. It may be shared with the people who would have sight of your CV. So although your right to privacy is there and protected by the Constitution, it would be limited in relation to those people who appropriately and relevantly would need to be given information about yourself that you had shared in relation to the recruitment phase. Another piece of legislation that's applicable is POPIA, which is the Protection of Personal Information Act. POPIA is anticipated to come into full effect now on the 1st of July, 2021. And we have been waiting for it for many years. And what POPIA does is that it protects people's personal information, and it protects the processing of personal information, which goes as wide as collecting, recording, sharing, storing personal information. And POPIA separates personal information and special personal information. And medical information would fall under special personal information. And this would apply to all data subjects, including applicants for employment, therefore, before you are even an employee. And then thirdly, the right to fair labor practices as contained in the Constitution. So the Constitution at Section 23 says that everyone has a right to fair labor practices, and therefore this would also be applicable to applicants for employment. And this would mean that really the labor practices must be adhered to fairly. So for example, even in relation to an applicant for employment, in relation to the recruitment, interview process, selection process in itself, the processes that are used, they need to be fair labor practices. And it couldn't be that just because someone is not an employee yet, that they can be unfairly treated in relation to that recruitment phase. So those are the legislations that are most applicable to people before they actually become employees. I'll now move to during the employment relationship. Now, as we know, there are many things that can arise during the employment relationship, but I've tried to select the ones that are most likely to apply in relation to an employee that has TB. The first one is sick leave. So during the employment relationship, it may be that because someone has TB, they fall ill and they're required to take sick leave. The Basic Conditions of Employment Act governs sick leave, and it says that employees are entitled to 30 days sick leave during a 36-month cycle, which is a 3-year cycle. Over and above that, the Basic Conditions of Employment Act says that during the first 6 months of employment, the sick leave entitlement is 1 day for every 26 days worked. So it may be that someone has TB and they then need to take their sick leave, and they would have this 3-year cycle to take their 30 days of sick leave as governed by the BCA, unless it's within the first 6 months, in which case they would have the 1 day for every 26 days worked. The second thing that may apply is a temporary incapacity. And this is set out in the Labor Relations Act, Schedule 8. And I just want to go specifically to that and just say and read out for you exactly what it says, so that I'm giving you exactly what the legislation says. So it says, incapacity on the grounds of ill health or injury may be temporary or permanent. If an employee is temporarily unable to work in these circumstances, the employer should investigate the extent of the incapacity or injury. If the employee is likely to be absent for a time that is unreasonably long in the circumstances, the employer should investigate all the possible alternatives short of dismissal. When alternatives are considered, relevant factors might include the nature of the job, the period of absence, the seriousness of the illness or injury, and the possibility of securing a temporary replacement for the ill or injured employee. So really in relation to a temporary incapacity, the Labor Relations Act in Schedule 8 requires that the employer should investigate the illness that the employee has, in this case, TB, and see if there are ways to accommodate the employee, including finding a replacement for the employee while the employee is temporarily incapacitated. So that's what the Labor Relations Act says in relation to a temporary incapacity. Moving on to occupational health and safety. The objective of the Occupational Health and Safety Act is to provide a safe and healthy work environment. Section 8 of the Occupational Health and Safety Act says this: every employer should provide and maintain, as far as reasonably practicable, a working environment that is safe and without risk to the health and safety of its employees. Now, there may be some workplaces that employees are more likely to be exposed to TB exposure, and this may be in relation to health workers, for example, and also those employees who work in the mining sector. In some instances have a higher probability of being exposed. And in relation to these employees, there's additional legislation that would apply to them. So in relation to the health workers, Healthcare Workers National Health Act, in relation to employees in mining, mining specific legislation in the Mine Health and Safety Act, and also Occupational Diseases in Mines and Works Act. So employers have an obligation to keep the workplace healthy and safe for their employees as far as reasonably practicable. Now, those words, as far as reasonably practicable, show us that the legislation in itself, recognizes that, it's not an absolute, but it does put an obligation on employers to do that, what is practicable to do in those instances, to keep the workplace safe and healthy for its employees. The next two I've mentioned already, but they would also, still be applicable during the employment relationship. The protection of personal information. So the person's personal information should be, protected in terms of POPIA during the employment relationship in itself. And also the right to privacy as contained in the Constitution would still apply. And the person's information should still be kept private as far as possible and as limited by the limitation clause that's contained in the Constitution. The other thing I wanted to mention that's very applicable during the employment relationship is a possible unfair labor practice. And this is dealt with in section 186(2) A of the Labor Relations Act. And that's what's most likely to apply to an employee in relation to them having TB. And again, I just want to read specifically from the legislation. So, unfair labor practice. It says, unfair labor practice means any unfair act or omission that arises between an employer and an employee involving. And then A says, unfair conduct by the employer relating to the promotion, demotion, probation, or training of an employee, or in relation to the provision of benefits to an employee. So in relation to an employee that has TB, they may find in the workplace that they are experiencing an unfair labor practice in relation to promotion or in relation to being provided with benefits, with equity of benefits as provided to all other similarly placed employees. And if this is the case, then they would have recourse by alleging an unfair labor practice and lodging a dispute at the CCMA. And the CCMA would hear the disputes and in the event that there really has been an unfair labor practice, that employee would be given the protections and recourse by the CCMA. The last thing I wanted to mention in relation to during employment was compensation for occupational injuries and diseases. So where someone is injured in the workplace or they are exposed to a disease in the workplace, and is as a result of or arising out of their employment, then they would be covered by COIDA. What this would mean is that any claim by the employee would be against the commissioner in relation to COIDA and would not be a claim against the employer directly. So this really gives the employer a space where they provide for COIDA as what covers an employee when there has been a disease that's occupationally acquired. And then lastly, I wanted to touch on the termination of an employment relationship. And I think there are various things that could apply here in relation to an employee that has TB. The first is an unfair dismissal. So in South African law, there are 4 basic reasons for terminating the employment relationship: misconduct, incapacity, poor performance, or the operational requirements of an employer, which is often spoken to as a retrenchment. Now, it would be important that in the event that the employment of an employee is terminated, that the reason for the dismissal is a fair reason and that a fair process is followed. So for example, if an employee has TB and the employer does not want them in the workplace, and then they say that they are wanting to retrench the employee, but that's not the true reason, and that actually there isn't an operational requirement to retrench the employee, it's actually the fact that the employee has TB that's problematic for the employer. That employee would have recourse in terms of our unfair dismissal provisions that are contained in the Labor Relations Act. So on termination of employment, it would be important to ensure that the actual reason given for the dismissal is the correct reason, and that a fair process is followed. Now, moving on to the next thing on permanent incapacity. So actually, it may be that on the facts, the employee is permanently unable to perform in the job that they're in, and the reason for that is the actual incapacity, and incapacity because of their illness in relation to TB, and that they're no longer able to continue in the role. And this is also provided for in the Labor Relations Act in Schedule 8. And I just want to go and read what is said there in the Code of Good Practice. Okay, so it says at 11, guidelines in cases of dismissal arising from ill health or injury. Any person determining whether a dismissal arising from ill health or injury is unfair should consider A, whether or not the employee is capable of performing the work, and if the employee is not capable, the extent to which the employee is able to perform the work, the extent to which the employee's work circumstances might be adapted to accommodate disability, or where this is not possible, the extent to which the employee's duties might be adapted, and the availability of any suitable alternative work. So where there's an ill health situation and the employer feels that actually the employee is permanently incapacitated, the provisions of the Labor Relations Act in Schedule 8 should be looked at and adhered to. And then lastly, it may be that there is termination of employment, but that termination of employment arises and amounts to an automatically unfair dismissal. Now, this may arise where the reason for dismissing an employee is based on one of the discriminatory grounds. Now, these grounds are located both in the Labor Relations Act and also in the Employment Equity Act. In the Employment Equity Act, they're provided for in Section 6. And let me just go there and tell you what is said in Section 6 of the Employment Equity Act. So it says, no person may unfairly discriminate directly or indirectly against an employee in any employment policy or practice in one or more grounds, including race, gender, sex, pregnancy, marital status, family responsibility, ethnic or social origin, color, sexual orientation, age, disability, religion, HIV status, conscience, belief, political opinion, culture, language, birth, or any other arbitrary ground. So you'll see that HIV status is specifically named here, but not any other ill health. But at the end there, we have the ground that says any other arbitrary ground. So what this means is that in terms of the Employment Equity Act, where it's one of the specifically listed grounds, the discrimination is assumed, and then the obligation is on the other party to show that actually there was no discrimination, or that it was fair discrimination. On the other hand, if it's not one of the listed grounds and a person wants to rely on an arbitrary ground, they would have to state what the arbitrary ground is. And in addition to that, they would have to show the negative impact on them by that arbitrary ground. So that's as provided for in the Employment Equity Act. And I'm now going to say and just read out what the provisions are in the Labor Relations Act on this. Okay, so this is in Section 187 of the Labor Relations Act that talks about automatically unfair dismissals. And at 187(1)(f), it says that the employer unfairly discriminated against an employee directly or indirectly on any arbitrary ground, including but not limited to race, gender, sex, ethnic or social origin, color, sexual orientation, age, disability, religion, conscience, belief, political opinion, culture, language, marital status, or family responsibility. So again, in the Labor Relations Act, we've got the stated listed grounds, but also it's also provided for that, including arbitrary grounds. So if a person feels that actually there's an automatically unfair dismissal, there's discrimination because of them having TB in the workplace, and they're able to show that this ground is the reason why they are being terminated and that it is unfair and discriminatory, then they would be able to show that it's an automatically unfair dismissal. Having said that, bear in mind that, where it is a case of a permanent incapacity, and factually it is a case of a permanent incapacity, that wouldn't be an automatically unfair dismissal if in fact the employee can no longer work because of their illness. It would be where, for example, the person can work or they're just being discriminated against and not because of them factually being impacted by the illness so that they are incapacitated permanently from performing in the position at the employer. So thank you. That's it from me this morning. I just thought it would be important to look at this aspect in relation to the various stages of the employment relationship and see how it is that an employee with TB may be impacted. Thank you.
Thanks so much, Lusanda. Are there any questions from the participants? Then, Lusanda, I'll start with one. In the recent silicosis class actions, was TB featured at all?
So TB was briefly mentioned, but in the silicosis cases, and I just want to go to the judgment now that you mention it. So in the silicosis cases, it was because of silicosis in itself, but it did say in the judgment and or contracted work-related tuberculosis. So that was in the July 2019 full bench judgment of Gauteng Local Division Johannesburg and the matter of Nkala and others versus Harmony Gold Mining Company Limited and others. And there were various mining companies that were involved there. But yes, TB was featured as part of that process and as part of that judgment.
And then we've got two questions from Alice and Intumbo. Alice, can you go first?
Great. Well, no, thanks, Lusanda. That's very for your comprehensive overview. I just had a question to get your opinion about the absence of the mention of TB in, say, the Employment Equity Act. Given the prevalence of TB in the country and the fact that it actually is the #1 killer here, even more so than HIV/AIDS. Do you think that perhaps these laws should be amended to specifically include TB as one of the protected classes, so to speak, as opposed to it needing to be under this category of the arbitrary grounds? And I thought of this particularly as you talked about the Employment Equity Act and how HIV is mentioned, but TB isn't.
Yeah, it's interesting that HIV is specifically mentioned as a listed ground,
Yes.
and TB is not. I mean, we haven't seen a move to try and amend the legislation to include TB. So Alice, I think, where we left at the moment is relying on that arbitrary ground catch-all that's been added to try and capture everything else. But there definitely isn't an active move to try and include TB as a listed ground.
Ntombotolo, can I hand over to you?
Yes, in our recent program of documenting human rights violations, we've come up against cases of people who have been dismissed for work. Some were co-infected, some had TB, DRTB, and they were dismissed under the pretext of retrenchment and all those things that you've mentioned. But some of these cases happened, the earliest was in 2012. was in 2012. I would like to know, is there any time limitations on how these cases can be addressed? Because these people are suffering. Some are living in poverty because they lost their jobs and didn't get any compensation. Even the retrenchment packages were so minimal. So is there any way of redressing these kinds of people when they are living in such abject poverty, but they have, some have qualifications, but they cannot get employment because it seems as if there is a network of blacklisting among employers, that when you get there, somehow people know that this is why you were dismissed from work, although it is termed as retrenchment. And that's my question. Is there any time that is set to redress this? Because we found these violations, but some were so far long ago. But the effects are evident now because of those.
Thanks, Ntombokolo. So in terms of the Labor Relations Act, after a dismissal, an employee has 30 days to refer an unfair dismissal to the CCMA. So they have that 30-day period. Having said that, after that period has passed, the CCMA allows dismissed employees to apply for condonation to the extent that they've missed that 30-day period. In a condonation application, though, you'd have to deal with various factors as to why you haven't applied within the 30-day period. And if the other party, the employee's former employer, objects to condonation, the CCMA would then have to consider that condonation application. So yes, there are time limits in the legislation, and to the extent that there's valid reasons why someone is outside those time limits, they are able to apply for condonation, but that condonation application may be contested by the other party, and then the CCMA would have to consider whether or not to grant condonation.
And then I see Miriam has got a question.
Can I make a follow-up question? Sorry, can I make a follow-up question for that? What if the person wasn't aware that there is a legal recourse that they can follow, or is the Labour Court not involved in this if the CCMA cannot assist?
No, so they would first go to the CCMA unless it's a large scale retrenchment, which would be within the realms of it going to the Labour Court. But they would first need, in the ordinary course, they would first refer an unfair dismissal to the CCMA. And then down the line, it may be that it goes for review in the Labour Court. But as I said, in the ordinary course for a single dismissal, the recourse would be the CCMA.
Okay, thank you.
Miriam, you can ask your question.
Okay, good morning, everybody. My question goes like this. I just want to check if whether this legal framework is applicable to other diseases or to other social issues. If they are applicable, how can we activate it, or how can we integrate it into our workplace as we are NGOs? Number two, I just want to check if whether this presentation will be available for us so that we can refer and be able to familiarize ourselves with, since some of the things we just hear them now and we're not sure of them, so that we can be able to share with, so that I can be able to share with my employees. Thank you.
Okay, so Miriam, if it's not one of the listed grounds, you would have to rely on it being an arbitrary ground for it to get the protections as provided for in the Labour Relations Act and the Employment Equity Act that seek to prevent unfair discrimination. So it either needs to be a listed ground. If it's not a listed ground, then yes, you could still have recourse, but on the basis of it being an arbitrary ground, and in the basis of it being an arbitrary ground, you'd also need to show on what basis that arbitrary ground has had a negative impact on you. The listed grounds are assumed. An arbitrary ground, you'd have to as an additional step, show the negative impact.
Maybe follow up. You know, I'm very much interested in this because I'm experiencing challenges with regard to my employees. Most of the time, most of them, they're seriously ill. And some of their work are affected because of their illnesses. So I just were busy communicating with the board on how best can we do this because it also affects their work. So that's why I need assistance, or maybe even after the meeting, how can I get assistance? Whom can I consult so that I can be able to get an advice on how best I can handle this in the near future for me to be able to protect the organization as well as myself as a manager.
Chantal, I don't know if there's additional ways to redirect Miriam in relation to probono.org after today. But your earlier question, Miriam, my presentation will be available after today.
Yes.
Yeah,
Okay,
if I
thank
can
you.
just do a quick interruption, definitely she can be in touch with probono.org and we could give her some advice about who else to approach if this is not something that pro bono could take on, given her status as an employer. But we certainly could give her some guidance. So be in touch with us. Thank you.
Thank you.
Teresa, can you ask your question?
Yes, thanks, Lusanda. And to Miriam, yes, you can contact our office and we'll see if we can refer you to someone who can help you with some advice with your issues as an employer. But Lusanda, thanks so much for the interesting presentation. I was just, and I think my answer is partially covered by some of your input, but just with regards to kind of the burden of proof, if an employee thinks that they've been unfairly dismissed because of their TB status, and they haven't, they haven't disclosed their status to the employer, but they suspect it's been gotten out and they go to the CCMA, is the burden of proof on the employee to show that the employer dismiss them for the reason of their status, or is the burden placed on the employer to show that prove that they didn't take into consideration the status of the employee?
Thanks, Teresa. Because it's not a listed ground, it's an arbitrary ground, the onus would be on the employee to show that that is the reason and to show the negative impact. If it's a listed ground, then it would be on the employer to show that it's not because of the listed ground. But because TB is not a listed ground, it would fall under the arbitrary ground, which would put the onus on the employee.
Okay, thanks. Can I ask another question out of curiosity?
Yes, sure. We haven't got any other questions.
If an employee is ill and but doesn't know that he or she has TB at the time that they get sick, and so they continue to come to work, and at some point they learn that they actually have TB. So if they've had a cough and have not been well, and then they go and see a doctor and discover that it's actually TB, does that employee have an obligation to disclose that status to the employer? And then what are the implications of that? And then secondly, if there's an obligation of the employee to disclose that they have TB and that they've been coming to the office coming to work not knowing that their status, does that employer then have an obligation to inform other employees that they may have been exposed without necessarily saying who would have exposed them? And then what are the implications for, issues around the right to privacy in instances like that?
So there isn't a positive obligation in any legislation to disclose your TB status. In fact, in relation to HIV, it's been said that the employees can't be forced to test for HIV. So there isn't legislation that puts that positive obligation. But having said that, from an occupational health and safety perspective, and to the extent that the employee would potentially be exposing other employees, it may be that they and depending on the workplace and privacy considerations and protecting their privacy, etc., that they do disclose to a trusted person at the employer. And it may be also, once they find out that they're ill, it may be that they need accommodation in the workplace, sick leave, temporary incapacity, etc. So for other employees in the workplace to make sure that they are kept safe, but for the employee in question themselves, so that the employer is able to reasonably accommodate them and reasonably find alternatives for them in the extent that they're actually getting ill and need to be accommodated in the workplace. They may need to disclose for their own protection.
Okay, thanks for that.
Lucinda, just in regards to the Employment Equity Act and automatically unfair dismissal, before the Employment Equity Act had actually mentioned HIV/AIDS as a ground of discrimination, there was discussion about relying on the ground of disability. And I don't know whether you could perhaps do that for TB as well, because then the burden would shift to the employer again.
Yeah, I'm not aware of actual case law that has said that it would fall within a disability. But I agree with you that, in terms of the listed grounds, it sounds like it's the closest listed ground. But I think we would need case law that specifically says, it's captured by that disability listed ground. And then, yes, that would help because it would shift the onus to the employer.
All right, do we have any other questions?
I have one more question. This is Alice speaking. I just wonder, I know of the case with regard to the prisoner who had TB and ended up suing the state, given the ways in which his rights were violated. Have there been any cases of state employees, prison guards, bringing lawsuits against the Department of Corrections for being exposed to TB or COVID or a communicable disease of that nature? And I just wonder if any of those cases have been pursued, if and then whether or not they were successful or where they stand. I know, just thinking out loud about these issues of the protection of prisoners, the protection of employees, and the obligations on the part of an employer, and in this instance, the employer being the state.
Not that I'm aware of, Alice. In relation to COVID-19, we've just had one of the most, early cases of litigation in relation to COVID-19, but it wasn't in relation to the state. The facts around that case were around an employee who'd come into the workplace when they were positive with COVID-19, and they'd hugged other employees and they'd walked around the workplace without a mask on, and they were then dismissed. So that case has just come out, but I think it's early days in relation to COVID-19. I'm not aware in relation to other cases in relation to TB, in relation to the state.
Yeah, thanks. It seems to me that might be, I'm a tad surprised that hasn't come up yet. That may be something on the horizon in terms of exposures, right? And, folk who could claim that they ought to be protected and are not being protected in the context of their employment. Yeah, but thank you.
Yeah.
So just in relation to your comments about COVID-19, Lucinda, we have a question from Margot, who wants to know, where does COVID-19 fall in this situation in the long term?
So last year, COVID-19 was specifically added as an occupationally acquired disease. So in terms of COIDA, compensation for Occupational Injuries and Diseases Act, COVID-19 was specifically added last year. So what it means is that in the event that an employee acquires COVID-19 in the workplace and they're able to show that they acquired it in the workplace, they could claim from the commissioner in terms of COIDA.
And then Ntombuqolo, you've got a question again?
Yes, I do have a question. In one of the areas I work in, it's a farm area which has seasonal workers. And now one of these workers maybe gets this is virtually what happened, although I won't be able to go into details. But this worker is a seasonal worker. So when the time for working to go back to work for the season, he fell ill and was diagnosed with DRTB. And then the doctor in the Department of Health approved it because obviously he doesn't qualify for all the workplace compensations because he's not permanently employed. He just works when the season is on. So he approved a grant that said we are high infectious, so I don't want you to go out and look for work. I will make a disability grant it's a 6 months grant for you. But now the challenge is this: the doctors at the social development saw how clinically well he looked, and then he said, "No, go to work. I cannot approve this grant because you look well." So where does this stand in the legal framework? Because the reason for the grant is infection control, but now the doctor who knows that this grant is infection control approves it, although the man looks well enough to work. But the one that was given instructions on how to approve grants, they said that the person must be close to terminally ill. So how do we address something like this? Because obviously the man has mouth to feed.
It sounds like there's conflicting views on the situation in relation to the sick person. And for me, to the extent that the person really is, too sick to attend at work, and they do have the one person who has said, they're sick and therefore qualify for the grant. I think if they were not able to work because they were sick, they would be justified in doing so and to show, that they're not fit to work. And it may be, given the nature of their work, it may be an incapacity situation. But I think, if factually they're not able to work, the employer would have to look at that and look at the fact that the person is not able to work. If the person factually can't work, they couldn't be forced to come into the workplace.
No, it's not the employer that forced. The person is unemployed for about 6 months of the year. So when the time for working came, because they usually go from farm to farm and look for work. So they are partly assured of finding a place in the farms. But the doctor said, I cannot allow you to go and look for work because you'll be working outside, aggravating your situation, and then you'll be infecting other people because at this stage, you are highly infectious. So I just want you to look at things like that because these are so prevalent in this area because it's a poverty-stricken area, and then people get only work in the farms. So if they can't go out to work because of the DRTB, it's got a high burden of DRTB. I won't disclose the area, but it's got a high burden of DRTB. And then now people, it seems as if now it's a challenge to get a disability grant so that the people can rest and say, oh, I won't go out to look for because I've got an income for the 6 months that I've got this infectious disease.
But I think though that, for the duration of the time that they are getting the grant, that's what the grant is for. So, for any time period,
after 6 months,
they're actually getting the grant. I beg your pardon?
After 6 months, it stops automatically. It doesn't even have to reapply. It stops. after 6 months, because the results of the test show that now the TB is on the road to be cured. So it's not infectious anymore.
So that if they're not infectious anymore, or the results show that they're now at a stage where they're not infectious anymore, then they should be able to go back to work. I think it's
and continue treatment.
it's whether they are able to work or not. If they're not able to work, then they're not able to work. But if they are able to work, should go back to the workplace.
Yes, and the grant, if
It
they are
depends
not
on the
able to
fact.
grant, it's extended if the grant is, if they are still sick and if there is evidence that they are taking treatment, then there are dynamics involved in how they get back to the grant. Yeah, but 6 months they have to go back to the doctor to be assessed again for the grant, but it stops first. Immediately after 6 months, it stops, and then they have to go back to reapply. The doctor assesses them and checks that blood tests to show that they are really taking the treatment. Otherwise, if it shows that they are not being serious, they are admitted in hospital so that they can be closely monitored.
Okay.
It's just something that was, we're not working in employee environments. There are these dynamics of the unemployed.
Yeah, and the grant system, really has its own complications. So yeah.
Yes.
So I'm going to close off the session. Lusanda's had to field all the questions by herself, and she's done a sterling job. So if I can hand over to Teresa Yates just to close off for the day.
Okay, I just firstly like to give a big thanks to Lusanda for your interesting and thought-provoking presentation, and for kind of carrying us through this on your own when Amelia had to withdraw. So thank you so much, and thank you also to Bowman's has been a long time supporter of the work of pro bono through some financial assistance, as well as through provision of pro bono services to our clients. So a big thank you really to you and the firm for that support. And thanks for everyone who has taken time out of busy schedules to attend another webinar. I know during these times of COVID that we can be a little bit overwhelmed with a lot of invitations to show up online. So thank you, and I hope that you found the presentation helpful, informative, and thought-provoking. I think for me, it certainly has been, and it certainly has highlighted gaps and challenges with regards to our legislation here in South Africa, and as well as the challenges that both employees and employers are facing when dealing with issues around health, and the need for employees to keep working, and the need for employers to try and maintain a healthy work environment. So it's given us a lot to think about, and I encourage anyone on the webinar who needs further assistance, or think that you do, to please contact any of the pro bono offices in Johannesburg, Cape Town, or Durban, and we'll try to assist as far as possible. And where we are not able to assist, try and refer you to the appropriate person or organization that might be. And finally, thanks to Chantel and Marco for pulling everything together and organizing these webinars under these kind of difficult times. We appreciate all that you've done for that. And really, finally, I guess, thanks to the AIDS Foundation of South Africa for funding this important work, highlighting the challenges of protecting and promoting the rights of people living with HIV and AIDS and TB. So with that, I hope you enjoy the rest of your day. Thank you.
Thank you very kindly.
And just a reminder to everyone that if you would like more resources, everything will be available on probono.org's website.
Sharp.
Thank you.
Thanks.
Thanks everyone. Bye-bye.
Bye.